Hear ye, hear ye. The Court of Appeals of the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution is on the court.
Please be seated. Good afternoon. Welcome to the First Court of Appeals. We have one case on this afternoon's docket, Lester Fisher versus the State of Texas, case number 01-22-328 CR. May we have appearances in this case?
Dawson Schindler from the Harris County Public Defender's Office for Mr. Fisher, the appellant.
Andrew Fletcher for the State.
Thank you. The appellant wishes to reserve time for rebuttal?
5 minutes.
Perfect. We will reserve 5 minutes for rebuttal, and with that, we're ready to begin.
May it please the court. In this case, the trial court erred and abused its discretion in failing to grant a mistrial after the most critical witness in the case, Taylor Batiste, invoked her Fifth Amendment right against self-incrimination rather than subject herself to cross-examination. The evaluation of whether a mistrial should have been granted, there's some controversy amongst the courts about how this should be evaluated. There's two cases out of the Court of Criminal Appeals, Archie and Hawkins, and I can give you citations for those. Archie is 221 Southwest 3rd 695, and Hawkins is 135 Southwest 3rd 72. Both of those cases consider improper prosecutorial argument in determining that the proper analysis for assessing whether or not the trial court erred and abused its discretion in denying the mistrial is the application of factors that were delineated in the case called Mosley v. State, which was 983 Southwest 2nd 249. And those factors are the severity of the misconduct, which is basically the prejudice, the efficacy of the measures adopted to cure the error, and the certainty of conviction absent the misconduct. So in essence, it's sort of like what this court would do in conducting harm analysis, but it would be done by the trial court at the time. So in real time, the trial court would be assessing the prejudice from the error, or yeah, from the complained of error.
Ms. Schindler?
Yes.
The trial court in this case did not apply those factors here, did they?
I do not believe that you can't. I would have to say no, because if the trial court did, I think that he would have granted the mistrial. You can't tell from the record how his analysis, how he conducted his analysis. But arguably, he was required to at least, consider the prejudice. The answer is I have no idea how he.
On the record, there's no discussion of Mosley at trial.
Right. No, there's no discussion of how he came to the conclusion that a mistrial was not necessary. There is one case, right, that is pending right now in the Court of Criminal Appeals on PDR, Hallman v. State, which is out of Fort Worth. That's 647 Southwest 3rd 805. And in that case, it was not a consideration of improper prosecutorial argument. It was a case where the prosecutor failed to disclose impeachment evidence in a timely fashion. And in that case, the Fort Worth Court of Appeals, the majority opinion, does apply the Mosley factors, despite the fact that it is not, a case that's specifically about prosecutorial argument, improper prosecutorial argument. And let me go back for a second. I'm sorry. In Hawkins and Archie, the reason why the Court of Criminal Appeals determines that the proper analysis is the Mosley factors is because they say that the denial of the mistrial, considering harm analysis, would be inappropriate because the harm hadn't occurred yet. So you're not, the error hadn't occurred yet. So it would be like considering it backwards. So in that type of situation, the trial court needs to assess it like in real time, whether or not this error is going to have a substantial effect on the outcome of the case. In Hallman, I'm sorry.
No, it's okay. Let me ask you about Hallman, and if you don't know, it's something we can check out later. But in Holman, is the error, you said it's failure to disclose impeachment evidence, is it posited as a constitutional claim like this one is, or is it more a
No.
non-constitutional claim?
Yeah, sorry, I was going to get there. Okay, so in Holman, it was a statutory violation. And the dissent in that case suggests that contrary to Hawkins and Archie, in that situation, the error has actually occurred. Okay, so you already have, the error wasn't going to be the abuse of discretion in denying the mistrial. The error is the state's violation of a statute. So you already have, you conduct harm analysis because the error has already occurred. So the dissent in that case distinguishes a situation where you have like a statutory violation versus where you just have an improper, argument by the prosecutor. I will point out that there are other cases that do not involve improper prosecutorial argument where the Mosley factors were applied more, and two of them are out of this court, Smith and Hernandez. And Smith was a violation of a limine order, and Hernandez was a co-defendant who testified in Spanish and without a translator. And in both of those cases, this court applied the Mosley factors, even though it wasn't about improper prosecutorial argument. However,
it sounds like neither Smith nor Hernandez involves a constitutional error.
No. And at this point, I'm not even referring to cases where you have a constitutional violation.
Okay.
I should have pointed that out earlier too. I'm very sorry. When you have a constitutional violation, it's a whole different situation. But the dissent in Holman suggests, well, I think I mentioned that, suggests that once you have a statutory violation, then it's proper to conduct the 44.2b analysis because you are in fact looking back instead of looking in real time at the situation. But in truth, the analysis is very similar, and it's kind of a distinction without a difference, because you're really just looking at the prejudice that occurred from the violation. And Holman is confusing in that regard because although they apply the factors that are delineated in Mosley, when at the end of their opinion, their conclusion is that the trial court abused her discretion in denying the motion for mistrial, and the resulting harm affected Holman's substantial rights. So that sounds a little more 44.2b-ish. So it's a little confusing. So like I said, PDR has been granted in that case, and I think that situation will be resolved hopefully pretty soon. But in this case, I would argue that the error here is constitutional. So the minute that Taylor Batiste invokes her Fifth Amendment right not to testify, Mr. Fisher was denied his Confrontation Clause rights. He had no opportunity to challenge her testimony, and this trial is more about her than it is about him. She is incredibly important in this case. So there, it's more like a statutory analysis type situation, except it's the Constitution. So you have the constitutional violation there, so you have delineated error. It has already occurred. It's not really a evaluation of the abuse of discretion. It's more a consideration of whether or not, like harm analysis, the impact of that error. Okay.
Ms. Schindler, I want to ask a quick question. Does it make any difference the fact that there was some cross-examination, a decent amount? I mean, it wasn't my case, so I guess it may not have been a decent amount at all. But maybe it seemed like they got you got some good kind of I don't know if it'd go so far to say impeachment, but she had to recant a little bit, minimize some of the things she maybe had said on direct. Does any of that? I mean, is it just the fact that the defense didn't get to finish cross-examining that makes it a constitutional error? I don't mean just, but
yeah, no, I think
because I do think there was, there are cases where this stops right after the state has questioned the witness and there's no opportunity for the other side. But when there's some opportunity, does that make any difference?
I believe that it does, and there is a case, and I will provide the citation for you, but it has to do with how much of her testimony was subjected to cross-examination. So if she testifies about a lot of things, and they only get to cross-examine her about a few of those things, then that is a constitutional violation. they have to have the opportunity to challenge anything that she might have said, you know, that would be false. And in this case, there's some evidence presented later that maybe she had been involved in setting up this situation, and he was clearly never provided the opportunity to cross-examine her on that issue. So I think it was pretty important that, you know, she, like I said, she is the most important witness in this case. There's just no way around it. And the idea that that Mr. Fisher didn't have the opportunity to challenge her credibility is just, you know, I mean, if the confrontation clause means anything at all, he was denied that right here. And so, again, going back to how we analyze the abuse of discretion standard, I believe here, since you have constitutional error, Mosley is not even applicable, or 44.2b. You're talking about 44.2a analysis. And there's two cases that where the Court of Criminal Appeals applies 44.2a to constitutional error in the mistrial situation. In Franklin, which is 138 Southwest 3rd 351, it was the denial of a mistrial after potential jury. Let's see what was. Oh yeah, okay. So in that case, a juror revealed during trial that she actually knew the complainant. So you have an impartiality issue there. And in that case, the Court of Criminal Appeals said that the trial court would have had to have determined beyond a reasonable doubt that that error didn't impact the outcome of the case. And I think that's what you have here. The trial court needed to determine at that moment that beyond a reasonable doubt that this denial of his right to cross-examine the witness isn't going to have an outcome on his conviction. And the answer to that is a resounding no. I mean, there's no way that her testimony didn't impact this case. And it seems like kind of intellectually dishonest to suggest that the jury wouldn't consider her testimony, that any kind of instruction to disregard would be sufficient, because she's referred to for, you know, throughout the entire trial, even after the jury was instructed to disregard her testimony. And her testimony was so critical that, you know, it's really, like I said, it's kind of intellectually dishonest to think that the jury didn't think about her and her testimony when they were deciding whether or not to convict Mr. Fisher. And I think that this court will appreciate that in attempting to do sufficiency review. I mean, are you really going to be able to evaluate the sufficiency of the evidence in this case without considering her testimony? I'm sorry, allergies.
While you take a drink, I have a similar question to my previous one, but as to the continued mentioning of her after the mistrial is denied. Kind of similar thing, what import is there in the fact that both sides continued to mention her? Does that play into any of the analysis?
Well, I think that the defense was forced to. They didn't have a choice. You know, they asked for a mistrial. They said this is a problem, you know, but they were forced to continue on with the case. They couldn't just ignore her.
Okay.
They really didn't have a choice. But the state, the statement that the state makes that, you know, he had threatened her because she was the only person that could place him at the scene seems makes it pretty obvious how, you know, how important she was to the trial. Let's see if I had something else I wanted to tell you. Yeah, I just wanted to reiterate the fact that there's no way an instruction to disregard her testimony could really have been effective, just because of the significance she played in this trial. It's one thing in cases where the witness is sort of redundant, or it's not that important of a witness, so, you know, they take the fifth, but there's so much other evidence in the record to support the conviction that it didn't really matter as much. In cases like that, I can see how an instruction to disregard might be effective, but that's not what we have here. In this case, you have the most important witness. Her testimony was critical. Her role in the situation is critical, and it would not be possible to just completely disregard her. It's just, you know, it's ridiculous to think that that was a possibility. And on that, I think I will rest my case, unless you have any further questions.
No, you've reserved time for rebuttal.
Yeah, thank you.
May it please the court, Andrew Fletcher, representing the state of Texas. I want to start off where opposing counsel ended, because I think it's actually at the crux of this case. And then I'll go through the entirety of this and the entirety of the defense counsel's argument and show you why all of that fails and the record doesn't support it. There was a mention about the idea of the witness being redundant and about it not matter. In fact, we have a cumulative testimony situation here, and that is why whatever test wants to be kind of brooded about, although we think that the Mosley factors will be the test that applies, that this is going to be found cumulative, and therefore even under a 44.2a analysis, it's just going to be harmless. So let's go and let's walk through several things that I don't want to miss. There's a mention about
Fletcher, if I can just kind of focus you a bit.
Sure.
Is there a place in the record where somebody directly identifies Mr. Lester as having shot somebody?
That Mr. Lester has shot somebody?
Yes. I'm sorry,
Yeah.
Mr. Fisher has shot somebody.
He does himself, yeah. His unintelligible statement, which is rather not unintelligible, does exactly that for about 30 minutes. I've attached that to the back of the brief. But don't take my word for it. I mean, we have the defense attorneys have that court exhibit, right, where they do exactly the same thing. And both parties in closing argument argue from it, so clearly it was intelligible enough to draw several things from it. So you can take the defendant's word for it, for one thing, which he says multiple times that he took care of TJ's business, is the way that he puts it. But besides that, we have Aaron Stewart, who testifies before Taylor does at all, and says essentially the exact same things as far as this one paragraph, which is really, despite the citing of like pages 141 to 148, really, it's all coming back to one paragraph on page 145. That's where all the damaging stuff that's alleged is claimed. And all of that stuff is pretty much the same. Let's count it out. Taylor's testimony was the only testimony to place him at the scene. Told her that he and TJ went and hit a lick. Guy ended up shooting TJ in the leg. That's when defendant came back around and killed the driver. We get exactly the same things from Aaron Stewart. So that pretty much makes it cumulative. But let's talk about Mosley for a sec. I want to talk about Hallman and just mention that Archie really resolves this in talking about 44.2a and still applying the Mosley factors. This isn't a question about the right that's at issue. This is about a question of the procedural stage that stuff is going on. So let's talk about it. When we talk about the Mosley factors, we have to have two things for this footstool. The first thing is that you have to have a sustained objection. What do you not have in a 44.2b analysis? A sustained objection. What do you not have to have in a confrontation analysis? A sustained objection. What did you not have in Bruton? A sustained objection. In fact, Bruton is entirely separate from all that stuff because of the fact that in Bruton we're dealing with a different type of limiting instruction. For instance, when we have joint trials in federal cases, of course, the confession is allowed to stay in. It's just told that it's going to be limited as to one or another defendant as to what the jury is expected to apply. Here, all of the evidence was struck completely. We have even the Ninth Circuit saying, yeah, striking stuff, I think I cite Lloyd's, striking stuff in its entirety is an extreme remedy. When we talk about the procedural history as it's represented here, and I would say also Justice Countess wrote last year, as far as I want to say Carter, in a claim about constitutional error, right? Of course that's argument, but it's my right to testify. Constitutional kind of right? And yet you're still applying that framework and putting it there. On top of that, you have, and so that's what we really have to have here. You have to have a sustained objection and then a request for mistrial. Now, what's the difference in terms of Hallman? Hallman isn't even a conflicting case. In fact, it's totally distinguishable. Why is it? Because we don't have that here. All they ask for there is a mistrial. They don't have a request, an objection that's denied. So really, I think probably if you think about it, when it goes up to the CCA, they're not really going to find that it is the same thing, and they'll probably go for 44.2. So I don't really think that that's really a kind of debate in the law. I think that everything, Archie, Mosley, Hawkins, is all saying we use the Mosley factors. Now, if you want to say that the right's more important, sure, although we didn't get a confrontation violation objection here, so considering Galladay and how you can't bootstrap stuff, maybe that's not preserved. But even if it is, then the idea is...
There was a confrontation objection here. Is that what you're saying?
I don't know that I would say that arguably there was, but assuming that there was, it would still fall under cumulativeness. So either way, it might not seem to be the case to try to finagle that when the Court of Criminal Appeals has continued to reiterate Mosley for this procedural situation. And ultimately, remember, the outcome is going to be the same. I would also point this court
Mr.
to-
Fletcher, I want to
Yes.
make sure I'm understanding
Sure.
your argument. Are you saying that 44.2A applies here, but in doing so, we use Mosley?
No, what I'm saying is that even if you wanted to say that the right was more important somehow and to somehow reflect that within Mosley, I don't know how you would. I wouldn't suggest that you do. I would just say that the things that that would go to is the efficacy maybe of the limiting instructions and things. But of course, it doesn't matter. It's not a Bruton claim. It's a narrow category of things that does not, that would be a confrontation violation. What I'm telling you is that we use Mosley. That's the first thing. Let's simplify that, right? 'Cause
And
there's a
that's
lot-
why, again?
Okay, the reason why is because when you have a 44.2.
I mean, why in this context?
Because this is a appeal of a denial of mistrial for exactly that reason. That's what this test is geared for.
So
Because it's-
any mistrial denial?
any mistrial denial is this one. And the
So
other-
how would anybody ever overcome the second factor? If a curative instruction, if we presume the jury, takes instructions, then, I mean, how is a defendant ever going to be able to overcome that?
Well, I think that you would look at the other two factors for one way. I mean, to say that the curative instruction was there, but like I'm saying, so let's take Bruton as a different example, right? And we're talking about the validity of a limiting instruction. Bruton has the holding that that limiting instruction wouldn't be enough, right? Which is why, foreseeably, the defense mentions it. But that's a narrow category. So in a true Bruton violation, right, if we had a co-defendant, right, and their confession came in, and it implicates Lester Fisher any more than he does himself, then that would be one of those situations. But this isn't that situation. So what I'm saying is that there are situations out there foreseeably where we could say that that second factor would be enervated, it would be dissipated, it would be much harder to show that this was strong. But the fact here is that not only do we have that instruction being given, after, by the way, the defense gets its request for what it really wanted initially, which is striking the testimony, but he then goes and asks, the trial judge, right, doing something, asks the jurors if they can follow it. This isn't a question of theorizing whether they could follow it. They said that they could. Now the idea is, are we saying that somehow that's not enough? This is why Mosley is helpful. It's where you get something, but you want more. That's what Mosley is geared to focus on. And that's just what our survey of the case law is focused on. I would also just point out that even in that circumstance, there's nothing, so let's go through sort of the defense part of what this is talking about. And let's talk about, I know that we had a mention about references. Let's talk about those. Because several of those that are represented as being the states are, as I think Justice Counsel points out, not the states. I count about 5 for both the state and the defense. I have mentions in terms of information received. I have questions in terms of Taylor mentioning Taylor. Mentioning Taylor, and the brief is artful in this because it says mentions of Taylor, not mentions of Taylor's testimony. Let's talk about that. This isn't, striking out the entirety of her testimony isn't like snipping somebody out of a photograph. They still exist in the world of the narrative and the story in the case. So for them to reference them isn't some massively prejudicial thing that somehow is immensely tainted. It just says, what are they talking about and how are they interacting with it? Now, if they went back and said, well, didn't Taylor say blah? Well, then that's something, right? I'm not unreasonable on that. It's just not this case. So when we look at these references, I mean, we have cross-examination. They're talking about Taylor selling cat and about being a cousin from Louisiana. Defense closing argument speculating that Taylor wasn't about the audio of the call. Again, look through the audio. And then also about how speculating that Taylor knew Essence. We're just speculating on that. As for the actual argument that the defense cites and leans on, I think there's a big problem with that in that you're not looking at the beginning of where that quote goes, which says, why is this important? He's not talking about what happened in Copper Lodge. They're talking about the defendant, Lester Fisher, talking about stuff in the audio. This is a valid thing for him to be talking about. He wanted to get rid of her before, he wanted to get rid of her afterwards. That doesn't mean anything because the only stuff that comes in is admission by party opponent. The same thing that it came in through with Aaron Stewart. It's the same caliber of evidence. So there really is nothing there. As far as what's represented, I want to talk also about how Taylor says nothing important. Nothing. Key critical witness, let's talk about that. I went through the entirety of her testimony because I expected that. So she talks about moving to Houston, where she moved here and where she lived, and how well she knew TJ, right? Her living at apartment 804, living at the complex of that apartment with TJ and a guy named Kay, her identification of Kay, her lack of a car and transport of TJ. By the way, this is already at page 130 of the transcript. What happened on 10/24, first during the day until after the group got back from Waffle House around 10 p.m. Is the Waffle House critical evidence?
I think the important part is on page 145.
I agree with you. I think that's exactly it, and that means that it's entirely cumulative. I mention that only because it's been represented that she's a critical witness, and yet she's saying exactly other things the defendant and another witness said.
Mr. Fletcher,
Yes.
you said that Aaron Stewart said similar or the same things as Taylor Batiste. Do you have page sites for
I do.
those
I do have sites
identical
for that.
things?
Yeah, absolutely can. And I have them also in the brief by themselves. Just refer you back to that in case, fallible as I am. So, Aaron Stewart's testimony does the same thing. TJ was trying to hit a lick and it went bad and he didn't make it. That's 4/112. TJ went up to the car and tried to open the door, and the person in the car put the window down and shot TJ out of the window after TJ pulled the door handle. That's 4/13. The appellant shot another person, 4/14. She said there were shots fired from someone else's gun, 4/14. The appellant said that he and TJ were going to hit a lick, 4/123. Seems pretty much the same. And if it is, then the claim should rightfully be resolved and the trial judge's ruling should be affirmed. But to go back to just I think then that I can sort of leave off and go into the rest of her testimony then and save the court some time, because I think that point has been made clear. I would also want to cite the court to just another case with regard to the probativeness, right? We're looking at a confrontation style, but in the Mosley context, in terms of the admission of a confession, right? That's going to be Lopez v. State, 2015 Westlaw 5783280. It's an unpubbed, but it's page 4, and that's from the Third Court of Appeals on 2015, and that's Pet Ref. And basically, the confession of the defendant there did not warrant a mistrial. So, I would say that with the understanding that Taylor has been shown, as far as her testimony, to not be super probative. I mean, even the other stuff we asked her, and I won't belabor it, but things about the backpack, right? Was there any weight to it? Did you look inside? Did it go with you? She says nothing. She doesn't remember anything. She said it felt light as a feather. She's really not a dynamite witness for us. And then I would also just point out that in getting this struck, who got...
Right, but she might have been a dynamite witness for the
For the defense?
in some ways. Like, how do you respond to that? Let's just like assume that we're looking at this simply on the constitutional error or deprivation. How would you tell us to analyze that?
In what? In a constitutional
In terms
error?
of just they did not get to confront the witness.
Well, I would say, I guess, are you, if I may, are you asking me to analyze from harm or from error?
Let's start with error. Actually.
Okay. So as far as error goes, if we're saying that they somehow weren't allowed to cross-examine her, as we have the citation to Villegas in the defendant's own brief, once the instruction was granted, it was as if her testimony never existed, right? But besides that, as far as not being to ask her questions, let's assume, I'll assume without conceding that you are asking if that there was a need to sort of cross-examine her. First off, the defense is right. There is a difference in terms of asking some questions, and they did get to ask some questions before the end of day on fourth volume. But I would say that even in the harm analysis part of it, again, it's confrontation. That's a Delaware v. Van Arsdale 44.2A analysis. Excuse me. Even under Chapman error, I'll give you a cite for that here. This should resolve all that. I'll direct y'all to what's called Harrington v. California. This is Justice Douglas from the Supreme Court of the United States, writing that there was, under Chapman, the cumulativeness of the evidence and the overwhelming nature of the evidence just meant that this was not going to be a harmful thing. So, in the same way, I mean, the real point of the answer that gets to what the crux of what the court would like to do or needs to do is it's just the same thing. The cumulativeness still applies, and so a lack of an opportunity to address would still be harmless, assuming that there was such an error. But again, you don't have to go into that, given that Mosley is the proper test. That's even true for Bruton harm, by the way. So I see though that I'm kind of tapering down there. I'm going to move on with that, unless there are other questions about the mistrial part of it. I'm going to move on to jury charge. I think that my brief speaks for itself on the sufficiency stuff. So what I wanted to get to was, I wanted to explain, I mean, we stand on what we say as far as the lack of entitlement to a jury charge instruction in the first place. As you know, do you believe is clearly asking for Terrence Ballet Sr.'s opinion and belief, not the defendant's. Helped is a past tense assessment, so it's really just kind of a result-oriented question. And more essentially, the standard for entitlement is loose, is not nothing. So I would cite this court, I know I cited the additional cases, but if you look at Smith v. State, 676, the Southwest 2nd, 584, that's talking about observable manifestations. None of these are present here. This is about a third-party witness speculating as to any sort of mental state. And so speculating about what defendant might have been thinking, is not going to merit an instruction. So there was no real entitlement here in the first place. There's no mention of any protection mentioned of TJ, so it's ambiguous at best, but what it really implicates is that he's a good partner. He's a good partner in crime as far as helping him and in committing this robbery. And the fact that it's saying like they're hitting him, that's no indication either. But more importantly than that, and I don't know that I'm getting any questions on that, so maybe there's no disagreement on this, is that it's shown that, and there's no dispute that there's no showing against Essence's use of force being lawful. I mean, it comports with 9.31 and 9.32a2b for the idea that Essence was at a parking lot of an apartment where he lived at 4:30ish in the morning and having two individuals that he saw, if you believe the defendant's statements, and that they refused to go away, and they continued to want to get him out of that car. As the defendant admits, they were playing it like we want some loud, playing it. It's false. And then they go away, and then they come back, and he starts yanking on the door. I think anybody in that circumstance would find that provocative, and that the victim would have a lawful right to defend himself in that situation. And because there are no showings on such a thing, or showings of an entitlement in that perspective, then there really is no entitlement there. That is true if you get past the fact that, as a matter of law, the defendant isn't entitled to a self-defense instruction in a robbery case at all. And so, I mean, we have cases that apply just that in the capital murder context. I want to cite favorably Justice Esguerra and Justice Landau, in your opinion, in terms of Fields, for just that idea, which is that we have two crimes being held in terms of all of the elements of the offense in the jury charge. And so therefore, even from that perspective, the jury is finding not only a murder, but a robbery at the same time. Just like, and so that's yet another reason why, just as a logical consistency point, you're just not going to have an entitlement there. I would finally just redirect in terms of the harm analysis for one thing, and I put these in the cases I was going to cite, Anderson and Cornett. Cornett talks about two different offenses that play off of each other, aka it was like a digital penetration and the oral anal contact as far as Cornett, and that they played off of each other as far as harmlessness. That is exactly the same thing here as far as the nested offenses of robbery and murder. They play off of each other. So there's no way of twisting the universe so that the jury would have understood and really rationally actually believed to say, well, yes, we found him guilty of murder and robbery at the same time, and yet we're going to turn around and say, is there a reasonable doubt that he believed that he was responding to unlawful force to protect his soon-to-be dead accomplice?
I'm gonna, real quickly before you,
Sure.
I know you're almost out of
Absolutely.
time, I should have asked this already.
No.
But I just discovered that I hadn't yet.
No.
Back to the initial issue we were
Yeah,
talking about,
of
that the
course.
letter was sent
Yeah.
on to direct you all. Have you looked at the De La Fuente versus State case out of San Antonio? Because that one is interesting to the extent that they didn't engage in the Mosley factor analysis when looking at whether there was a confrontation right violation, but they did use the Mosley factor analysis when addressing the prosecutorial misconduct claim.
Mm-hmm. And what's the, I was just
It's
asking.
De La Fuente versus State,
What's the-
432 Southwest 3rd.
And so in the procedural history part of that, I imagine that the confrontation clause the confrontation clause objection was not sustained, it was denied, right?
I don't have that in this, I
Okay.
just have the whole, I mean,
I
I
would
just have the
suspect-
analysis from the holding.
I would suspect that that's the case, because that's what they're geared toward, right? When you have a denial, if I may finish the answer to this one, thank you. When you have a denial, then it's still out there, it's floating out there in the aether, right? And of course, even then, I mean, with Snowden v. State, you'd still consider the weight of the evidence, but not just as dispositive. But when you have this situation where you have the granting of the objection, right, which has happened here, and then you have the request for additional relief, the mistrial part of it, and that is denied, then that's the focus of the Mosley test of the analysis. Because it's having to balance out the efficacy of the instruction that is given, along with the difference as far as whatever taint or prejudice or harm is concerned. So we can see that there is, as far as what the state did not emphasize, as far as the cumulativeness, that this is just not a case where relief would be granted on that basis. The mistrial, I mean, the judge is always having to look in a mistrial at, as it happens, Johnny on the spot kind of thing. It's impossible to sort of foresee what will come in, what won't come in, and to prognosticate in this way. So even though there's not any real application on the record of sort of saying, well, I'm going to read the factors or whatever, we have a bunch of cases that continue to apply that analysis regardless of any sort of record indicia or breakdown of what the ruling was. And so, anyway, with that, I see I'm and therefore I will end my argument, and I ask this court to affirm. Thank you.
I just wanted to point out a couple of things. Obviously, the record will speak for itself, but the testimony of Ms. Batiste was not redundant. Aaron Stewart does not implicate Mr. Fisher. She says that he told her he was at the apartment complex, but not at the scene. She makes some assumptions about it, but she admits that those were assumptions, and he did not tell her that he was there, and she had no knowledge. She had absolutely no personal knowledge and no secondhand knowledge of the events that occurred there. In addition, the state attached to his brief a good faith transcription of the unintelligible phone call. Obviously, that's not in evidence. This court is aware of that. Any reference to that should be not considered by this court. That said, there is a transcription of that phone call in the record that's certified. It's Defense Exhibit Number 1. That can be obviously considered by the court. And one thing that, in that conversation, I mean, it's very difficult to figure out what they're talking about. There's really nothing in there that could be specifically referred to that implicates Mr. Fisher. He does talk about how he was spending time with TJ, speaking to his father, because he felt like TJ was making bad decisions and he wanted to look out for him. So, you know, there is some evidence there of his mindset in terms of the, his right to an instruction on self-defense or defense of another. But really, like I said, the record will speak for itself with regard to the redundancy issue. There is no evidence in this record that can place Mr. Fisher at the scene, and proof of that is the fact that Detective Reinhardt will testify, I think it's volume 4, page 84, that Mr. Fisher became a suspect when he went to Louisiana to interview Taylor Batiste. Well, he'd already interviewed Aaron Stewart. He didn't say Mr. Fisher was a suspect. He says he became a suspect when he went to Louisiana and interviewed Taylor Batiste. So she is the one that created this idea that Mr. Fisher was involved. She's the only one that could place him at the scene. The state admits that in their closing argument. Her testimony was absolutely critical. And when you go through the phone conversation, not that you can really understand what they're saying, but you will see that they're only talking about her. Like, that entire conversation is about her. And I'm not suggesting that she couldn't come up again in the case just because her testimony was struck. But if you look at, and this is where my point with regard to an intellectually honest evaluation of the sufficiency of the evidence, can you understand what they're talking about when it comes to Ms. Batiste if you don't think about anything that she said, anything that she had to offer? Does it even make sense You know, what is the context of the references to her without her testimony? So, you know, I don't think it's possible for a human brain to do that, to just completely eliminate, you know, that level of evidence that you heard, and not consider it at all in reaching your conclusion in this case. And I think, like I said, I think that you will realize that when you do sufficiency review.
Ms. Schindler, how do we reconcile, though, this sort of presumption that the jury follows the instructions that they're given?
Well, I think that's rebuttable here because, for one, her testimony was so critical. So, and two, it's rebuttable because she's referred to so many more times in the record. I mean, she's very important. So it's impossible to say that that instruction was sufficient to eliminate consideration of her testimony. I mean, you just can't.
Is there no, I mean, is this a case where no instruction would have been sufficient?
Yeah, and that's exactly right. Yes, it is. And also, I'm not sure that it matters because I still, you know, believe that this is constitutional error. So you're not even performing that kind of analysis. You're analyzing it based on the 44.2a, where can you determine beyond a reasonable doubt that her testimony, the error didn't impact the outcome of the case. And I think that the answer to that is a resounding no. I mean, you can't, there's just no way that you can look at this case and think that the jury, oh, they definitely followed this instruction. It would be impossible. It's just not even possible. And if you look at Franklin and Barnett, the cases where the Court of Criminal Appeals does apply the 44.2a to a mistrial situation because it was constitutional error, that's what they do. They don't talk about whether or not an instruction would be sufficient. They go straight to the point. You know?
I'm sorry to interrupt, I just know you don't have a lot of time left. In holding the way you would like for us to hold, if we were to find that the judge abused his discretion in not granting the mistrial, what was he supposed, like, I mean, I think that's a little bit of the trickiness here, right? Like, if the Mosley factors don't apply, then what case was he supposed to, or what case law, or what was supposed to be guiding his decision making? Because I'm
that's
struggling
where,
with that.
like, I would refer you to Franklin and Barnett, where the standard is the trial court should have, at that moment, made a determination beyond a reasonable doubt that this error is not going to impact the outcome of this case. And it's almost like you're guaranteed a mistrial if the error is constitutional. Because I don't know how you could ever determine beyond a reasonable doubt that it didn't affect the outcome. So, you know, in a case like this where you're analyzing the impact of constitutional error, I'm not sure that any of that matters. What the trial court should have done is thought at this moment, okay, can I determine beyond a reasonable doubt, if I deny this mistrial, that her testimony isn't going to impact the outcome? Well, of course not. Of course it's, there's no way. I think that, it was a clear abuse of discretion to deny a mistrial in this case because her testimony was so critical, and because she played such an important part. There's just no way that any kind of limiting instruction was going to resolve the error. And with that, unless you have any questions.
We have your arguments. Thank you both.
Thank you.
Case is submitted and we are adjourned.
All right.